There's been a seismic shift in how firearm laws are shaped and enforced in this country, and chances are it slipped right under your radar. It didn't dominate headlines, but make no mistake, it changes the entire playing field. This is something that has been quietly building for decades, largely unnoticed by the general public. If you're the kind of person who's been tracking how agencies like the Bureau of Alcohol, Tobacco, Firearms, and Explosives have slowly been expanding their reach, writing rules out of thin air, and enforcing things Congress never explicitly voted on, then you'll want to pay close attention. The landscape just changed, and not by a little bit. We're talking about a legal quake that impacts every gun owner in America, whether or not you've ever personally dealt with the ATF. The old playbook, Chevron deference. For decades, the ATF operated under something known as the Chevron Doctrine, a legal standard born from a 1984 Supreme Court case, Chevron USA, Incorporated versus Natural Resources Defense Council. Incorporated in simple terms, the court decided that if a federal law was vague or unclear, government agencies could interpret it however they thought reasonable so long as it wasn't outright ridiculous. The thinking was that these agencies had experts who could fill in the gaps. But what started as a way to keep government machinery running smoothly turned into an open door for regulatory overreach. Agencies, like the ATF, began stretching old firearm laws far beyond what Congress ever envisioned. Take the National Firearms Act or the Gun Control Act, both written decades before things like pistol stabilizing braces, three-dimensional printed receivers, or forced reset triggers even existed. The ATF's mindset became, if Congress had known about these, they would have regulated them, and with that, they'd issue a brand new rule. No new vote, no updated statute, just a decree from the agency. Suddenly, something that was perfectly legal under the actual law could become a crime simply because of a fresh ATF interpretation. It created a strange twilight zone where the written law said one thing, but the ATF acted as if it said something entirely different, and most people never noticed it happening. The game changer, Loper Bright Enterprises versus Raimondo. That all changed in June of 2024 when the Supreme Court decided Loper Bright Enterprises versus Raimondo. In that ruling, the justices tossed the Chevron doctrine in the trash. They made it clear that unelected bureaucrats don't get to decide the meaning of laws. That job belongs to the courts. From now on, judges will interpret the law directly, without blindly deferring to agency expertise. What does that mean for the ATF? It means when they claim, this accessory turns your firearm into a machine gun, a judge can now push back and ask, where exactly in the law does it say that? And if it's not there, the agency's word doesn't carry automatic weight. This shift applies to every federal agency, the Environmental Protection Agency, the Food and Drug Administration, all of them. But for those of us who've been keeping tabs on the ATF's more creative interpretations, this is monumental. It cracks open the door to challenge a long list of controversial rules that leaned on Chevron, from so-called ghost gun regulations, to 80% lower receivers, to bump stock bans and forced reset trigger classifications. And already, some courts, especially in the southern states, are starting to revisit these rules with fresh eyes. The new reality. The tables have turned in a big way. For years, the Bureau of Alcohol, Tobacco, Firearms, and Explosives could decide on their own what counted as legal or illegal, and we were just expected to fall in line. Now, that game is over. They have to walk into an actual courtroom, face real judges, and answer direct questions. And those judges are going to hold their actions up against the plain text of what Congress actually wrote. That completely changes the playbook for challenging new regulations and even how the agency tries to create them. This new legal climate means a lot of folks who were once branded as criminals for owning something as basic as a pistol stabilizing brace might finally have a fighting chance. We've already seen lower courts tossing out ATF determinations, and it's picking up speed. The old rule, the ATF says it, so its law is gone. Now judges are stepping in and saying, show us the law from Congress that backs this up. Even old rules aren't safe anymore. Not long ago, even when a regulation felt flat out wrong, courts usually shrugged and said, we've got to defer to the agency. That era is done. Judges can now strike down anything that doesn't line up with the actual statute. That means past bans, enforcement tactics, and definitions can all be put under the microscope. If Congress didn't pass it, it's sitting on shaky ground. Now, don't get me wrong, the ATF still has teeth. They can draft new rules and issue guidance. But the difference is, they know they can't count on automatic deference. If they cross the line, the courts will smack it down. So you'll probably see them writing tighter, lawyer-proof rules to survive in court. That's how the system's supposed to work. We may even see them try to push Congress into rewriting the National Firearms Act or the Gun Control Act. Politically, that's an uphill battle, especially with the country this divided. But expect them to run big public relations blitzes after any high-profile shooting, trying to rally support for more restrictions. The fight ahead. This Supreme Court decision is a major win, but the fight is far from over. What it really does is move the battle to a different field. It puts the responsibility back on Congress exactly where it belongs. If a new gun law is going to happen, it should go through open debate, get voted on, and face public scrutiny, not sneak through as some agency memo. That's why backing the organizations on the front lines, like the Firearms Policy Coalition and Gun Owners of America, matters so much. These groups are filing lawsuits, challenging overreach, and making sure the ATF is held to the letter of the law. And the results are showing we're seeing real victories. But none of it happens without steady pressure, in the courts, in politics, and in public opinion. So, yes, celebrate this ruling, but don't relax. The ATF isn't packing up and going home. They're still writing rules, still pushing, and still supported by politicians who want tighter gun control. The difference now is they can't do it in the shadows anymore. They've lost their shield. And that gives us breathing room and the chance to push back harder than ever. Let me make something crystal clear. Just because the Bureau of Alcohol, Tobacco, Firearms, and Explosives got smacked down in court doesn't mean they're suddenly hanging up their hat. History shows us their playbook. 1 year pistol stabilizing braces are perfectly fine. The next year they're prohibited. Then they're conditionally acceptable. And before you know it, they're classified as short-barreled rifles. This constant flip-flopping has been a deliberate tool. By keeping gun owners unsure of what's actually legal, they've been able to scare people into compliance either by staying silent or by getting rid of perfectly lawful gear just to avoid trouble. That tactic has been effective for decades. But now, the courts have stepped in with a stronger voice, and that changes the whole game. It means that past rulings, especially those built on the now dismantled Chevron deference, are suddenly vulnerable. People who were caught in no-win legal situations, whether facing charges, losing property, or having their gear banned based purely on agency interpretation, finally have a shot at justice. And that's the key difference here. Law is written by Congress. Interpretation is just an opinion. The court has drawn a hard line, and now every agency is being told to stay inside it. One of the most encouraging signs? The speed at which lower courts reacted after the Supreme Court decision. It's like they were waiting for the permission slip to stop rubber stamping whatever the agency said. Now they can look at the actual statute, compare it to the facts, and make an independent call. That's how the judicial branch is supposed to work. Still, the fight is far from over. The same people driving aggressive ATF rulemaking haven't gone anywhere. They'll repackage the same restrictions with new language, hoping something sticks. Some of those efforts might survive unless they're directly challenged, which is why awareness and legal pushback are critical. We've entered a new phase, and every legal victory now has the potential to ripple out far and wide. And let's not underestimate the power of public pressure. Whether it's contacting your elected officials, supporting pro-Second Amendment legal groups, or simply keeping your fellow shooters informed, that engagement makes a difference. Agencies rely on the public being too distracted or too intimidated to resist. But when the firearms community stays vocal and unified, it becomes a lot harder for overreach to slip through unnoticed. I know it's tiring. There's always a new proposal, a fresh ban, or a surprise regulation, but if you've ever wondered whether fighting back matters, look at what just happened. A decades-old legal doctrine that let agencies act like lawmakers is gone. That didn't happen by accident. It happened because people organized, attorneys fought, and judges listened. So yes, this is good news, some of the best news gun owners have seen in years. It doesn't mean the war is won, and it doesn't mean the ATF won't take another swing, but it does mean we finally have the legal footing to go on offense, not just play defense. That's where things stand right now. I want to hear from you. Does this feel like a turning point? Are you optimistic about where this goes next? Or still cautious about what new angles the ATF might try? Drop your thoughts in the comments. And if you found this breakdown useful, hit that subscribe button. I'll keep tracking these changes and walking you through every development. Until then, stay sharp, stay safe, and keep holding the line.